Talking again about terms that you may hear in legal dramas or on TVs or movies in the courtroom. A common term that you will hear, and frankly, it's present in every single case, is the burden of proof. What is the burden of proof? Well, like most things in the law, it's a little more complicated than just a single straightforward thing. But in essence, whichever party has the burden of proof means that they have the obligation of meeting the standard or proving whatever the elements of their action may be. For example, in a criminal case, the burden of proof is on the state to prove that the accused committed the crime beyond all reasonable doubt. That is their burden of proof. Not just more likely than not by clear and convincing evidence, but beyond all reasonable doubt. Similarly, in a civil case, if someone hurt you and you bring them into court and you file a lawsuit as a plaintiff, the plaintiff, the person bringing the case, has the burden of proof, but it's different. It's not that criminal burden of proof. It's by the preponderance of the evidence, the slightest tilting of the scale. It's People think of it as a football analogy. It's not a really good football analogy because in this football game, the ball would have to start on the 50-yard line. And if the plaintiffs advance that ball half a yard, they've met that burden of proof by the preponderance of the evidence. So the burden of proof is really the obligation to prove whatever it is that you have to prove, and it usually belongs to the ones who are bringing the lawsuit or bringing the action. Not always the case, however. If you're asserting an affirmative defense, for example, if you're saying, hey, I'm accused of this, but I'm mentally insane, or there's some other defect that I think it's your fault. Defenses, the burden of proof shifts to the person who's presenting that defense. All you need to know is that the term burden of proof really means who has the obligation of proving to you what they say is true. But those burdens can be radically different, as we've discussed.